SJC-13254, Commonwealth v. Hubert L. Smith, and SJC-13253, Commonwealth v. Frank DiBenedetto.
Attorney Campbell.
Good morning, and may it please the court. Cailin Campbell on behalf of the Commonwealth. I'm in the unusual position today to be both the appellant in one case and the appellee in the other combined case. So I'm asking you to do two different things. The first is, as to Mr. Smith, to reverse the allowance of his post-conviction motion, and the second is, as to Mr. DiBenedetto, I'm asking to affirm the denial of his post-conviction motion. Both present the same legal question, which is whether locked pleas are constitutional, but with...
Well, do they really? I mean, isn't the first one that this is a done thing and now we're into a different situation? We're not in the plea package, actually. Isn't that true?
Correct.
For both of them, they're not in the plea package because the condition didn't happen.
Correct, and I believe that they show sort of... You're right. I think at the most basic level, they present a question, which is whether locked pleas are constitutional. How that question applies to different factual scenarios, I think both are in different places. I would agree with you there. With the court's permission, though, briefly before I get to that issue, I would like to address the issues raised in Mr. Smith's appeal, which concern the time frame and the deadline for filing gatekeeper petitions. I disagree with my sister that a rigid application of 30 days should apply. I don't believe it finds support in any of the appellate rules, any of the rules of criminal procedure, or any case law that exists.
Well, if 30 days is good enough for the defendant under Maines, why isn't it good enough for the Commonwealth?
I'm not saying that the 30-day deadline in and of itself is problematic. I mean, I do argue that it should be extended because for everybody, not just a defendant. I think
why? All
parties, because the 30-day deadline, if you look at Maines, it references Rule 4, which is just referencing filing a notice of appeal, which is a single piece of paper. A gatekeeper petition is a substantive pleading that could have a devastating impact on the further litigation of the case.
So what should be the deadline?
I think a 30-day deadline with recognition that if there is an extension for time, that extension for time can be granted. I think it's just the rigid application of that 30 days, and if you don't do it within 30 days, then you're
But it's precluded. So you filed a notice of appeal.
Correct.
And a defendant arguably can file a notice of appeal right away.
Correct.
And then have the 30 days to say, I need another, I need more time to file my petition.
Correct. And I think that could be what this court says. I think the confusion, at least on my part, came from the practice that I believed that the single justice preferred, which was not to file a motion for an extension of time or a placekeeper petition, but to file a petition with a motion to accept it as timely filed. And if you look in the past 11 and a half years, I've done that
How they come.
almost 20 times. And in this case, I didn't expect that it would be a problem given the notices of appeal that were filed and the express communications I had with defense counsel as to the reasons why I needed the additional time, which was to obtain the transcripts because I was not the original prosecutor handling the motion. But I think this is a good opportunity as it relates to generally the good cause standard, because when you look at both the rules themselves, the reporter's notes to the rules, and the case law, there isn't really a good articulation as to what the good cause standard is. There is
sort of garden variety miscommunication is not usually good cause. I think that's clear.
I don't under the case law, I don't believe that that's clear.
What case stands for the proposition that garden variety miscommunication is good cause?
I don't think there's any case that states that it isn't. I think if you look at the cases that do exist, it largely is if the Commonwealth offers no explanation as to the delay at all.
The other problem, I mean, I understand the COVID problem, and I understand one of the other ones, but the problem in which the assistant DA says to use, and I did, and you check a couple times, you're still in the same office, so you have to own that mistake.
And I do. I do. I think if you're looking, the good cause standard, even the silver standard that's employed, talks about unusual circumstances. I believe that falls into the category of an unusual circumstance. And so
what does? The miscommunication between you and your...
I believe so, yes.
But you're still the DA.
I understand that. I understand that. And I think, Other than it happened, I own that it happened. I don't think it should preclude the Commonwealth where there is a substantial issue such as this one from going forward. And to support that, I would rely on the cases in my brief which talk about this, even in cases where the Commonwealth has offered no justification
So let's
at all.
talk about the substantial issue in Smith.
Certainly.
How would this not violate double jeopardy at this point?
I don't believe it would. If you look at the cases that discuss double jeopardy, specifically if you look at a case like Lowy or Solefka, there is a much longer period of inaction. Also, if you look at Commonwealth v. Sanchez.
But he was resentenced and paroled.
Absolutely, but
So he can't be sentenced again?
he absolutely can be sentenced again. If you look at, yes, at Commonwealth v. Sanchez, and Commonwealth v. Sanchez, there was a similar reduction under the verdict under Rule 25b2. The Commonwealth filed a notice of appeal. There was a resentencing.
I guess the issue is whether or not the sentence is, so to speak, crystallized, because in Sanchez, there was a notice of appeal. So in that case, there's a less of an expectation of finality. Here, there's a notice of appeal, but a missed deadline on the gatekeeper. I think that's the distinction, at least it's argued in this case versus Sanchez, correct?
Correct, but I think if you look at Sanchez, it talks about the defendant being on notice.
Right.
That this isn't
So the
a-
defendant's on notice.
Correct.
After he wins the motion for new trial, he waits his 30 days, you don't
Correct.
file, he says, great.
I don't believe so because I think it's more complicated on that given the facts, right? So there's a June order, Judge
But we're
Sanders says,
all right, go in the defendant's position. It's the whole issue of whether or not the sentence, there's an expectation of finality based upon a missed deadline, essentially.
absolutely, and I think if you look at the case law, specifically if you look at the Lowy case, in that case, the Commonwealth didn't take action for 16 years, and it was an unexplained 16-year period of inaction.
And I get the disparity that we're talking about in Maine's in 30 days, because defendants can just file another petition.
Correct.
But
Correct.
be that may, you don't have double jeopardy rights, the defendant does.
We don't, but I don't believe if you're looking at double jeopardy and specifically fundamental unfairness, I think if you have two notices of appeal, if you have specific articulation that we are pursuing a gatekeeper petition, we're just waiting on a transcript, I don't believe that crystallization has occurred where there are these express communications.
But doesn't the crystallization, even though there's communication between the DA and the defense, at some point, something has to happen on the record in both courts so that the courts know, or the courts wouldn't know that this was in this state?
That's where I think that there's confusion in the case law because it's unclear. I think typically a notice of appeal would serve that purpose, as it did in Sanchez, as it does in countless other cases.
We get a ton of notices of appeal that don't go anywhere.
I understand that. I think there's a difference here where there's a notice of appeal and express communication as to, I need the transcript, I'm waiting for the transcript. Now, will I own that it would have been more proper for me to have filed a motion to stay or a placeholder motion? Absolutely, but again, I'm relying upon my 11 years of practice with the single justice in which they stated that the preference was to file it with a motion for timely filed. And that has been held to excuse missed deadlines in the past as it relates to, I believe, the Commonwealth and the defendant. So I would rely upon that as to why it doesn't violate double jeopardy. I think it's certainly different than Lowy, in which there's a 16-year unexplained absence. I think it's even different from Solefka, in which it's a year after the sentence is imposed and the Commonwealth with no explanation then goes to try to change the sentence after the defendant had already served the committed portion of his sentence. And I would point to Sanchez, in which it says the defendant's custodial status, because in Sanchez too, he had been resentenced and released, bears no, in terms of the double jeopardy analysis, no bearing on the double jeopardy analysis. So I would point to those three cases in combination. Pointing to, though, the constitutional issue, because I see I have 5 minutes and 40 seconds left, there's really a difference in framing what the issue is between myself and both of my sisters. And they point to Lafleur and Fry and say, Lafleur and Fry stand for the proposition that a trial doesn't cure any defect in the plea bargaining process. I don't believe that that's precisely the holding of Lafleur and Frye. Lafleur and Frye stand for the fact that a defendant is entitled to effective representation, which he inarguably has a constitutional right to. And if he gets that during a plea bargaining process, then the remedy is for the plea offer to be offered again. Here, there is no right to the plea offer itself, and what the defendants are challenging is the constitutionality of the plea offer itself. That changes the analysis and really makes Lafleur and Frye.
Well,
Go ahead.
sorry, go ahead.
No, please go ahead.
I mean, aren't they, as I understand defendant's arguments, is that once the prosecutor decides to engage in a plea bargain process, that process needs to be fundamentally fair.
Yes, and I would...
What they're saying is that when you make it impossible for me to accept the plea unless I coerce or convince my co-defendant to also accept it, that's fundamentally unfair.
Correct, and I don't believe if you look at it under a traditional due process type of analysis that it is fundamentally unfair, because typically under a due process analysis, you just ask whether there is a rational basis for the action that is occurring. And here there is a rational basis. Plea bargaining is recognized there's a mutuality between the parties. A defendant is giving up rights and the Commonwealth is making a charge concession. The Commonwealth is typically making a charge concession in order to gain a conviction or avoid trial, but if you have two co-defendants avoiding trial, that doesn't exist unless they both plead guilty. I'd say that in itself is a rational basis that supports that it's not fundamentally unfair. Also, there's nothing in the record, and I think this is where Mr. Smith and Mr. DiBenedetto are different. There's nothing in the record that they were precluded from pleading generally. They could have pled to the indictment. Mr. DiBenedetto could have offered a plea to second-degree murder. There's nothing to say that they couldn't have engaged in a different type of plea negotiation. And there's also nothing to say that a conditional offer generally is something that isn't permissible under the law. I think fundamental fairness contemplates, as it generally does in a constitutional analysis, that it's not based on some impermissible classification, that it's not based on a defendant choosing to exercise his rights. And certainly here where there's a rational basis that I've just articulated, it would pass constitutional muster. I think it's also interesting to say, if you're thinking of fundamental fairness, that a defendant could come to a prosecutor and a prosecutor could just say no, and there's no problem with that. But if a prosecutor does say, sure, but it has to have this condition, that wouldn't pass constitutional muster.
And I suppose one of my questions about this is that as I understood that original package approach in this case, in Smith's case, it was a good offer up until the close of evidence, correct?
Correct, that's what this court has found.
But at that point, that offer wasn't there anymore.
Correct, and this court has held by the time that he attempted to accept the offer
That's
didn't
Smith.
exist.
And the co-defendant got to plead, but because of the question from the jury, but that was a different situation. That was not under this package deal, right?
No, it was not under the package deal.
So there was no package deal in place at the moment that the defendant tried to take it. Is that true?
Correct. And I would say Smith is unusual given the age, given the amount that we know about the plea bargaining process, both because of what happened in the trial transcript itself, but also immediately there was a motion for new trial where testimony was taken, where both the trial prosecutor and the defense counsel testified as to what had happened. And I think when you look at that testimony, it really bears the danger in a loose articulation as to what an offer is, because this court has already held that there was an offer, but if you look at what the testimony actually is from ADA Mundy, he's approached and he says, I won't even consider an offer unless it's both of you. I don't know how that transforms into an offer for purposes of specific performance, because there really aren't any terms, right? There's a lobby conference in which the judge says, what's it gonna take to plea? And ADA Mundy again says something akin to, it needs to be both of them and it would have to be something like second-degree murder. So I think that shows sort of the looseness with which these plea bargaining could happen. Mr. DiBenedetto was in a different posture than Mr. Smith, but again, I don't think there's any showing of acceptance or trying to accept, which is problematic. I also think that if you're looking at specific performance for both defendants, there's a problem because neither were ever offered a standalone plea. And that's where it gets to, again, to bring it back to the fundamental fairness, where you have two defendants who are the more culpable of the pair, A package plea offer is giving them maybe more of a charge concession than they would have otherwise got. Maybe more of a charge concession than they would have got if they were a standalone defendant, which in both of these cases are horrible on their facts and straight first-degree murder. So the incentive for the Commonwealth to plea it, there would have to be a concession from a defendant. I have 5 seconds left. I'm happy to answer any questions that the panel may have. Otherwise, I will rest on my brief. Thank you.
Nicely done. Okay. Attorney Menken.
Good morning. May it please the court. Attorney Michelle Menken on behalf of Hubert Smith, who is present in the courtroom, having received a reduced sentence and gone before the parole board, obtained a positive vote, and achieved release. With the court's permission, since Counsel for Benedetto and I are splitting our argument time, I intend to focus my argument on the timing question, and Attorney Greenberg will.
I'm sorry, I couldn't hear that. Which
The
question?
timing question,
Okay,
the
thank you.
threshold determination of whether the Commonwealth's appeal should be dismissed. And Attorney Greenberg will focus on the merits issue that's common to both appeals. But I
Okay.
will take just a moment, since the facts of Hubert Smith's locked plea were just discussed, to clarify a few things. One, it's absolutely clear on the record that Mr. Smith tried to accept the plea offer multiple
But wasn't that
times.
after the evidence closed?
No, it was not.
When was it?
So he approached the plea discussions
Oh,
early.
I see. So
and
you mean
often
when the
he
when the
requested-
co-defendant wouldn't agree to it?
That's
That
right.
part of it.
That's
Okay,
right.
I got
And
it.
he did make motions, I believe, twice to the trial judge to allow him to plead guilty to second-degree murder, and he was forced to stand trial. The plea that occurred happened after the conclusion of the evidence, so I think that's clear. With regard to the timing issue, my sister started her argument by suggesting that there shouldn't be a rigid application of the means rule, and by that I understood her to mean that this court should have discretion to allow enlargements in the interest of justice. So what I think is really important to recognize is that if there has been a reduction in sentence, a reduction in verdict, if the time is going to be enlarged, there is a potential due process problem bubbling, because the longer the defendant is serving his new sentence, the more his interest in that sentence crystallizes. Now, this is different from the double jeopardy issue, and it's important to clarify. Under the law and under the rules, when the time to appeal has passed, the conviction is final. Then the double jeopardy issue arises. You cannot impose a new sentence after the expiration of that period. So that's an issue in this case, because nothing that the Commonwealth did halted the finalization of the judgment. And I will point out that to this day, the Commonwealth never sought a stay, never sought to stop the prejudice from accruing to Mr. Smith, even after it was clearly on notice of what was happening. So if there is going to be an enlargement of time, that may avoid the double jeopardy problem, but it won't avoid the due process problem. And
Well, even if we said, this is a tight time frame and we need something new, it still would be something for future cases, not past cases.
Absolutely, that's
that
true.
right?
That's true. So I'm just sort of speaking prospectively. It's clear that in this case, Mr. Smith's interest in repose crystallized at the expiration of the 30 days. And what's interesting about the Commonwealth's
Well,
position...
can I just push back on that? I mean, so the Commonwealth filed a notice of appeal after the post-conviction motion was allowed in June 2021. Then there was the reduction to the murder 2, and again, the Commonwealth files a notice of appeal. Then there was the resentencing that happened in September, and again, the Commonwealth provides notice through an email saying, hey, I'm just waiting for a transcript. Why, given 2 notices of appeal and an email saying we intend to appeal this whole post-conviction thing, that happens after your 1994 conviction, why isn't that enough to put the defendant on notice that to the extent he's intending to crystallize anything in his mind, it's subject to the clear intent of the Commonwealth to appeal this whole thing?
So I have a couple responses, and one was what I was about to get to. But one, I'll point the court to Commonwealth versus Bouvier, which embodies a pretty intuitive principle that it doesn't matter what the Commonwealth intends to do. They have to actually take action to make it happen. And
Well,
Mr.
is
Smith,
it that they have to take action or that the defendant has to be put on notice?
they have to take action.
Because
they
that
could
would
change-
notify the defendant, or why is
Well-
it the act, what action does the Commonwealth have to take? I am not suggesting that the Commonwealth took the actions that were appropriate, but what in your mind would be enough?
A motion to enlarge, a motion to stay, anything.
And what would that accomplish for the defendant that wasn't accomplished by the way the Commonwealth did it here?
It has the actual effect of halting the proceedings. It has-
And you would have been able to file a motion to, an opposition.
I could have filed, he could
If
have.
he, if that were filed, you could have, the defense would have a chance to file an opposition, is that right?
That is part of the equation. But the other is that if the Commonwealth changes its mind, I mean, bear in mind that there was a change of leadership in the district attorney's office in this time period, and months went by with no communication between September and January when the parole hearing took place. And Mr. Smith, who is facing the decision of whether to see the parole board, which was a very taxing process for him, needs to know. He needs to know officially. And
But
what I was going to say was...
The stay would have put the parole board on notice as well.
Absolutely. And all of
So we wouldn't have gone through this, and could have been an empty process without.
Absolutely,
without
for
this.
everybody. It's a tremendous expenditure of resources on everybody's part.
And
and
I don't want to, have you finished answering Justice Wendlandt's question?
So the Commonwealth, what the Commonwealth's position and what you're suggesting, that they have this idea. That
I'm
they're
just asking
going to-
questions. I'm
yes,
not
right,
suggesting
But they have
anything.
this idea that they're going to go forward. What it ignores is that those rules that allow for that avenue are completely discretionary. So their argument takes shelter in the presumption that they're going to be allowed an enlargement and they're going to be allowed permission to appeal. And at the same time, simultaneously suggesting that Mr. Smith should not take solace, should not take shelter or rely upon the rules that speak with definiteness. And, the U.S. Supreme Court has emphasized, and it should go without saying, that one of the primary purposes of these rules that set these deadlines is to put the defendant on notice that it's over.
I thought you agreed that the good cause standard is applicable.
I do think that the good cause standard is probably, as opposed to the lesser standard, I think they have to, but no, all of the Commonwealth's excuses, even the good ones,
Okay,
and
but
we argue, don't explain.
You're not answering my question. It's applicable, correct?
It's applicable.
All right, let me ask you a different question. Due process, double jeopardy, obviously, the Commonwealth doesn't have those rights, the defendant does. But in your mind, is there a way a defendant can forfeit the right by an untimely filing of a gatekeeper petition?
Forfeit the right to a gatekeeper petition by not timely filing?
Right.
Yes, and I think that happens all the time. I think that gatekeeper petitions...
Don't you just file another one?
I'm sorry? File another gatekeeper petition?
Right.
After the expiration of the time? I mean, it'll be denied on the grounds that
And
it's
we had
untimely.
this below, and I had asked for examples.
Yes, and I provided, I believe, 5 examples. And there's also the consequence to the defendant of what happens in
And I think
federal court.
in all those cases, the court has said it wasn't timely filed on the mains. But anyway, and
also it
reaches the merits,
merit.
correct?
So I
think this is more of a concern, the mains rule, frankly, for the federal court than it is for us.
well, for the defendant, who has.
No, for the federal court, when they look at it,
In
it's
the
on
federal
habeas.
court context, that's right. I
Right.
mean, the Maine's rule has real palpable
That's what I mean.
consequences to
It's-
defendants
we're really
in federal court.
Right.
It's a bona fide deadline as far as defendants are concerned.
And I think obviously the reason it was reported was to get some clarity on what past practices are and what Maine's really means, or whether it should continue.
And I think that one thing we've emphasized in the brief is how difficult it is to collect and analyze those cases because they're not reported or cataloged. And so we did our best anecdotally to pull together the cases. But it's pretty clear that this is being applied to the
So,
defendant's
If we
detriment.
were to change the main time limit, what do you think would be reasonable?
Well, I agree with what was suggested earlier, that a 30-day deadline is fine to file something. And what I'm emphasizing is that in a case where a defendant is now serving a new sentence, one of the things that needs to be filed is a motion for a stay.
What's your position on the Commonwealth's view that, as it relates to timing and what's filed, that they were following past practice with the single justice?
Well, I think there's those past practices relate to Rule 15 motions, which do have a set of rules around them, and also they concern interlocutory appeals. So this is what I'm emphasizing. It's really different when all of a sudden there's a new sentence that's in effect, because that gives rise to these constitutional concerns. In an interlocutory appeal, those concerns are not present. But I also, again, I think that argument reflects the position of privilege from which the Commonwealth is coming, because it's talking about this insider knowledge of clerk's office practices not codified in any rules.
We're pretty generous to everybody, aren't we?
Absolutely.
Have you
And
ever?
myself included.
So you don't get the privileges from the clerk's office? Is that what you're saying?
Well, it's not, listen, I'm an
Let's be
attorney,
right.
but there are pro se litigants. How are they supposed to know? I mean, that's the point of the rules.
We don't really deny these. I mean, you've raised a much more complicated problem, which is when the sentence is changed. But we've been unbelievably generous to both sides in keeping these things focused on substance. We've not been policing timing too much, have we? I mean, I've been a single justice a lot of times. I can't remember ever denying a late one.
A late gatekeeper petition?
Yeah.
Well, I think that there are several, it's very, very common for a single
I
justice.
suspect I'm not alone.
There are many single justice decisions where the decision is it's untimely and has no merit.
Right, but that's how we do it, right?
Right. So, but the thing is that statement that it's untimely has consequences when the defendant
For the
proceeds
feds.
to habeas.
Yeah, for the feds, not for us.
That's right. For the defense, not for you. If there are no
And can
more
you
questions.
just take 2 seconds to spell out for all of us what that consequence means on the federal system?
Sure, it's a procedural default that bars habeas review. And in fact, even if in
So isn't it really that EDPA says 1 year after the 30-day deadline elapses, that's it for the federal habeas?
That's right.
Right.
And so if let's say an untimely gatekeeper were allowed to proceed and then the defendant lost on appeal and then went, and this happens, there's a case cited in the briefs, and then went for habeas review, all of the time between when the 30-day mains deadline and the date that the petition was allowed to proceed untimely, that still counts against that EDPA 1 year. I see that my time is well over. Thank you.
Thank you. Okay, Attorney Greenberg.
Thank you. Ruth Greenberg for Mr. Di Benedetto, whose family is here today. I'd like to start with...
Can I ask you to speak louder?
Oh,
or
I'm
move
sorry.
the mic?
Better?
Thank you. Yes.
Better, I need the mic. I'd like to start, with my points of agreement with my sister.
Well, can I ask you
Yes.
to start with the correct constitutional test, which your Commonwealth articulates as a rational basis test. Do you agree with that?
Well, the test here is whether the government's action offends, is offensive to implicit concept of ordered liberty.
Well,
That's
you
the
have no
test.
right, the defendant has no right to a plea period, and the defendant has no right to have a guilty plea, the defendant has no right to a plea deal, period. The defendant has no right to have a guilty plea accepted. Are you suggesting that there's somehow a fundamental right not to have a package deal?
That's exactly what I'm saying, and that's just where I was going to
So you're
start.
saying, and where would I find legal authority for that, given what I just said about the first two? No plea deal at all, and then no right to have the plea deal accepted.
Those are two separate questions.
But they're related,
I
so can
agree
you
with you.
explain how,
Yes.
given those two things, you're nonetheless finding a fundamental right to a non-package deal?
Yes. Yes, I can. I agree with you. I agree with the court and the precedent. There is no right to a plea offer. If the Commonwealth had made no plea offer in this case, I would not be here. But the Commonwealth did make a plea offer. When the Commonwealth makes a plea offer, that plea offer, the process of that plea offer, since Lafleur and Frye, is constitutionalized, and it's entitled to constitutional protections. It's not, as my sister says.
Well, yeah, I mean, it would be entitled to constitutional protections. The question is it strict scrutiny or rational basis? It's strict scrutiny if you're right that there's a fundamental right to a non-packaged plea deal. But if it's not a fundamental right implicit in ordered liberty, then we default to rational basis review.
Why is it not a fundamental right implicit in ordered liberty?
Well, yeah, that was my question to you.
My question to and yes, that's good.
It turns out I wear the
good.
robe, I get to ask the questions.
No, we're good. We're asking the same question, and the answer to that,
Sure.
yeah, we're good. I used to teach for Stanley Kaplan. What's the opposite of the word order? The opposite of the word order is random. And what the Commonwealth is saying is these are at best.
All right, let's
a package
just say
plea is random.
I disagree with you that there is actually a fundamental right, and that there is a right to a fairness in the plea deal process. So, for example, the prosecutor couldn't say, I offer this deal to you because you're white. And that would be a problem if there were some sort of irrational, unconstitutional classifications going on. But here, the Commonwealth saying, I want it all or nothing. I want either I go to trial or I don't go to trial. And so you committed this crime allegedly with two other people. You get everybody on board, and that way I don't have to go to trial. Why isn't that a rational way of pursuing that legitimate state interest in preserving resources and not having the victims have to testify?
Because it's not static. The Commonwealth could say that. Let's assume the Commonwealth said that. Let's assume then defendants A and B say we choose to trial. In that case, the Commonwealth is going to trial. The Commonwealth is now going. Costa wants a trial. The Commonwealth is trying the case. At that point, what does the Commonwealth owe to Benedetto? Why are the actions, since the Commonwealth is now trying the case anyway, time is moving, things are changing, the Commonwealth's trying the case.
Well,
Why is it not vindictive to punish
Because
de
we have to
Benedetto?
figure out what rational basis is for that. There's a lot of things going on when there's co-defendants, not just that it's more arduous and difficult to try right from the impanelment on. And a lot of times, if you have co-defendants, you're going to offer a deal well lower than you would with a standalone plea for a multiplicity of reasons. Sometimes you've got, as we've alluded to, witnesses who it's going to be really difficult for them to testify. And the DA makes a judgment call to offer a package deal. So it's not whether the question now is not whether that puts the defendants in a difficult position, puts them in a very difficult position, even if there is no right to a plea. The question is whether or not those reasons have a rational basis.
But the question is, those reasons have a rational basis when? They might have a rational basis before the defendants plead, But after the trial is set, that rational basis vanishes. It wasn't a rational, there was no rational basis to try De Benedetto just because Costa is being tried. If anything, the Commonwealth,
But you're making a judgment about the Commonwealth's use of its resources.
yeah, it's
Okay.
gone. It's gone. There is
So we should
no,
ask the defense attorneys what the prosecution should do, how they use their resources, who they should give a deal to, who they shouldn't give a deal to,
But
who
what
they're worried about coming in and testifying for the defense.
you're not looking at the movie. When you look at that might be true at the beginning, but it's not true after Costa decides to go to trial. Once Costa decides to go to trial,
Who's in a good position to assess the use of the Commonwealth's resources?
at that point,
Right.
it can't be easier to try two than one.
Okay, in your opinion, as a prosecutor, right?
There's no rational basis to believe it's easier, no legitimate basis to believe it's easier to try two
Based
than
on
one.
your
How could
experience
it
as a
be?
prosecutor, right?
I don't want to quarrel with you, Judge. What reason could there be that makes it easier to try two than one? If they're being tried, what makes it easier? How could it be?
Well, I
I don't
guess
want to
that-
debate you about 30 years of experience, but whatever.
I mean, that if this court, let's talk about how we decide what shocks the conscience. Is this a practice that if there's a member of the court that's engaged in this practice and looks at his own experience and says, I did it, it must be right, that judge
Counsel, I
should
don't
not
think
be
that's what
sitting.
anybody's saying or suggesting, and I don't think that's a good avenue to pursue. What I might pursue is why, in this instance, should your client not have why should we not affirm this, since everything seems to be procedurally intact here, except for your constitutional plea question, which we may or may not agree with?
This is the question that's before the court. May the government, looking at the trial of two people, where the government is now compelled to proceed to trial in any case, compel the second defendant to proceed to trial only because the first defendant chose to go to trial? It appears on those facts that the defendant who wanted to plead is being punished because the first defendant refused.
What are the terms of that plea?
The terms of the plea here were, the offer was, you can plead if Costa does. Costa refused.
Okay, and there wasn't, so that, the condition precedent didn't happen. So there is no deal on the table.
But it's not governed, as my sister argues, by strict principles of contract law, because the position of the government in such a contract is so far superior. It's not a contract question. It is a fundamental fairness.
Going all the way back to Santabello, the issue is there a right to specific performance? And the question becomes, specific performance to what?
So in this case, the plea offer was clear. 2 manslaughter sentences if De Benedetto could somehow force Costa to plead, which De Benedetto declined to do. You know, I want to take just one moment to talk about the Hampden County amicus in this case.
Before you switch to that,
sorry.
so they can't switch they can't change their mind, okay, if we're going to try 2, the manslaughter was okay, but, that deal is off. I mean, they could, you could propose another, as your sister argues, you could propose second degree or whatever. Are you bound to the original? Is that what you're saying? That's a violation of substantive due process if you change from the manslaughter to something else?
It's a violation of due process with regard to Mr. De Benedetto.
Well,
Because-
my question,
because
because we're not
it's-
just deciding Mr. Di Benedetto's case, we're
it's-
creating a precedent. I'm just trying to understand, are you saying you can't change that at all?
It's fundamentally unfair to not let Mr. De Benedetto get the benefit of the offer
remember,
because of
from what
Costa's
I understand,
actions.
you changed this sort of paradigm a little bit. You say, look, okay, once Mr. Costa refuses to go, then we're just looking at the benefits to the Commonwealth of 2 versus 1, right?
Right.
But so now that original deal, which they were prepared to, because of no victim testimony, nothing, they were giving out a lower, they were giving manslaughter at that point. They can't change from that because now the victims have to testify. They're going to be re-traumatized. Can't make any changes? That's still a violation of substantive due process?
Yes, because that's not Mr. De Benedetto did nothing to cause that. He's being punished for something which he didn't do.
Being punished by getting his constitutional right to a trial.
But that's what Lafleur and Cooper say. That argument is no longer good. That's what changed.
Those were ineffective assistance of counsel cases.
Those, in the Scalia dissent, we can see that we have provided these all constitutional protections as part of the plea bargaining process, all. So just as Justice Wendlandt said, we can't offer plea bargains only to white people.
No, I'm
we
just
can't
asking.
offer plea bargains only to girls.
My question is, as we try and understand those cases, aren't they ineffective assistance of counsel cases, not locked plea cases?
There is no locked plea case. There is none. We went through all the possible precedents. The only one that's actually
One in
applicable
Pennsylvania?
is the Pennsylvania case.
Right.
Yes, that's the only one, and it's the only one where the argument is.
Trial level?
I'm sorry?
Trial level Pennsylvania
Yes.
case, if I'm remembering
I thought the
correctly.
circuit courts have addressed this.
The circuit courts addressed these questions prior to Lafleur. And other than those, they're sort of all oblique. We run through it in a brief. I don't want to take my minute.
Well,
But
you're actually 5 minutes over, so I'm going to ask you to wrap up. Just
okay, let me say, why, when the government made that offer to Frankie, it wasn't supposed to only consider horse trading. The government wasn't only supposed to consider its costs, its conveniences, and random effects. The government made an offer to Frankie that they felt served the justified and legitimate purposes of punishment. The government was satisfied that the public safety would be protected, that it would recognize Mr. De Benedetto's willingness to plead guilty. They were set. It was a fair sentence, according to the Commonwealth, 2 manslaughters on this case. So we're not revisiting, and that's where Judge Lang erred. He said, well, it's a fair sentence. But that's not the question, because the Commonwealth determined what a fair sentence, what a fair punishment would be for a person who accepted guilt. And they looked at Frankie and said, if you accept guilt, this is a fair punishment for you, and the interests of society will be served. However, go make that other guy do it, or you can't have it. And that's a very dangerous practice for the Commonwealth to have, because it encourages terrible behavior and it punishes good behavior. It punishes a person who doesn't bully his co-defendant or force his co-defendant into taking a deal, and it has a ripple effect in the community. Because even if the defendants say, I'm not going to bully my co-defendant, words get out and all their friends can bully the co-defendant. It encourages government, it's the government encouraging bad conduct.
Do you think it encourages the Commonwealth not to give plea deals?
Why would it do that? I mean, I know I don't get to ask the question. No. It encourages the Commonwealth to offer plea deals.
Co-defendants, they say, nobody's getting a deal.
That would be fine.
That
Would
okay.
be fine.
Okay.
That would be fine. We accept that would be fine. What wouldn't
Well,
be
it was a
fine?
joint
are you
venture.
accepting that for all the defendants out there?
Yes. Yes, it's the law. The Commonwealth, it's not up to me. The law is clear. The Commonwealth does not have to
All I'm
offer
saying
deals.
is I'm not sure that everyone would agree to accept.
But I mean, they don't have to. It's the law. It's not up to me. What's up to,
I was
what
asking
my
about the
argument
law.
is
That
once
was
they,
asking about whether or not that would be a good prerogative for the DA to
just say,
engage in.
"Never mind."
That's what Justice Gaziano's question was. It wasn't what the law is as to whether or not there's a right to a plea offer.
Should the Commonwealth just say, well, we won't do that anymore since it causes so much trouble?
the Commonwealth should not do it anymore because it's an abuse of power.
Saying plea deals altogether. Plea deals altogether. Should they just be done away with and just have everybody go to trial?
You know, the Santabello talks about this. Bordenkircher versus Hayes talks about this. When a plea, Bordenkircher versus Hayes is a case the court wants to look at.
But
that
that's
there's
a reliance case.
Well, it's not exactly a reliance. I mean, it's kind of a reliance. Yes, it's a reliance. But it talks about the difference between the legitimate power of the government, like in the Santabello line, negotiating with one person. The government is allowed to say, if you don't take this deal, we will indict you as a recidivist offender. And that's fine, because that's the terrible choice that a criminal has to make himself. That's the exercise of his individual autonomy and his relationship through counsel with his government.
Thank you.
But that's not what we have here.
Got it.